Modern Real Estate Practice, page 161. Figure 10, period 1. Agency disclosure form continued. Agency relationships in real estate transactions, page 2. Dual agency. Broker representing both seller/landlord and buyer/tenant. Dual agency occurs when one broker or salesperson represents both parties to a transaction, or when two salespersons licensed to the same broker each represent a party to the transaction. Dual agency requires the informed consent of all parties and means that the broker and salesperson owe the same duties to the seller/landlord and the buyer/tenant. This role limits the level of representation the broker and salesperson can provide and prohibits them from acting exclusively for either party. In a dual agency, confidential information about price, terms, and motivation for pursuing a transaction will be kept confidential unless one party instructs the broker or salesperson in writing to disclose specific information about him or her. Other information will be shared. Dual agents may not advocate for one party to the detriment of the other. Within the limitations described above, dual agents owe to both seller/landlord and buyer/tenant the fiduciary duties described below. Dual agents must disclose to buyers material facts as defined in Minnesota State Statute 82.68 sub D3, of which the broker is aware that could adversely and significantly affect the buyer's use of enjoyment of the property. Minnesota Statute 82.68 sub D3 does not apply to rental/lease transactions. Facilitator. A broker or salesperson who performs services for a buyer/tenant, a seller/landlord, or both, but does not represent either in a fiduciary capacity as a buyer's/tenant's broker, sellers/landlord's broker, or dual agent. The facilitator, broker, or salesperson does not owe any party any of the fiduciary duties listed below, except confidentiality, unless those duties are disclosed in a written facilitator services agreement. The facilitator, broker, or salesperson owes the duty of confidentiality to the party, but owes no other duty to the party, except those duties required by law or contained in a written facilitator services agreement, if any. In the event a facilitator, broker, or salesperson working with a buyer tenant shows a property listed by the facilitator, broker, or salesperson, then the facilitator, broker, or salesperson must act as a seller's/landlord's broker. See paragraph 1 on page 1. In the event a facilitator, broker, or salesperson working with the seller/landlord accepts a showing of a property by a buyer/tenant being represented by the facilitator, broker, or salesperson, then the facilitator, broker, or salesperson must act as a buyer's/tenant's broker. See paragraph 3 on page 1. The disclosure is required by law in any transaction involving property occupied or intended to be occupied by 1 to 4 families as their residence. The fiduciary duties mentioned above are listed below and have the following meanings. Loyalty. Broker slash salesperson will act only in client's best interest. Obedience. Broker slash salesperson will carry out all client's lawful instructions. Disclosure. Broker slash salesperson will disclose to clients all material facts of which broker slash salesperson has knowledge, which might reasonably affect the client's use and enjoyment of the property. Confidentiality. Broker slash salesperson will keep clients' confidences unless required by law to disclose specific information, such as disclosure of material facts to buyers. Reasonable care. Broker slash salesperson will use reasonable care in performing duties as an agent. Accounting. Broker slash salesperson will account to clients for all clients' money and property received as agent. If sellers slash landlords decides not to agree to a dual agency relationship, sellers slash landlords may give up the opportunity to sell slash lease the property to buyers slash tenants represented by the broker slash salesperson. If buyers slash tenants decides not to agree to dual agency relationship, buyers slash tenants may give up the opportunity to purchase slash lease properties listed by the broker. Notice regarding predatory offender information. Information regarding the predatory offender registry and persons registered with the predatory offender registry under Minnesota Statute 243.166 may be obtained by contacting the local law enforcement offices in the community where the property is located, or the Minnesota Department of Corrections at 651-361-7200, or from the Department of Corrections website at www.core.state.mn.us. Page 162. Single agency. In single agency, the agent represents only one party to a transaction. The real estate must provide fiduciary common law or statutory duties exclusively to one principal within the transaction, who may be either the buyer or the seller, or the landlord or the tenant. The customer is the party not represented by the agent. See Figure 10.2. While a single agency broker may represent both sellers and buyers, or landlords and tenants in separate transactions, that broker cannot represent both the buyer and the seller, or the landlord and the tenant in the same transaction and remain a single agent. Single agency thus avoids conflicts and results in client-based service and loyalty to only one principal in any transaction. On the other hand, it necessarily limits the broker's client base by ruling out the sale of in-house listings to prospective buyers. Another agency relationship that involves one principal and one agent is the relationship between a real estate broker and a sales associate of that broker. The employing broker is the principal, and the sales associate is authorized to conduct real estate business only as an agent of the employing broker. The sales associate owes the broker that same fiduciary duties that the broker owes to the client, the broker's principal. The sales associate owes those fiduciary duties to the client as well, because as the agent of the broker, the sales associate is the sub-agent of the client. Seller representation. If a seller enters a listing agreement with a broker to market the seller's real estate. The broker becomes an agent of the seller. The seller is the principal, the broker's client. The broker is obligated to deal honestly with all parties in the transaction and act within the licensing law. The broker is strictly accountable to the principal, the listing contract, the document that usually forms the agency relationship, or broker and seller, typically authorizes the broker to use the services of sales associates employed by the broker, as well as the services of other cooperating brokers in marketing the seller's real estate. Figure 10, period 2, single agency. It shows the agent on top, and it shows a steady line down to the client. And on the other side of the agent box, it shows a dotted line to the customer. Buyer representation. A buyer who contracts with a broker to locate property and represent the buyer's interest in a transaction is the principal. The broker client, the broker as agent, is strictly accountable to the buyer. Although it has been customary in commercial transactions, buyer agency is relatively new to residential practice, but is quickly becoming a popular area of expertise. Real estate commissions or boards across the country have developed rules and procedures to regulate the buyer's agent. Local real estate associations have developed agency representation forms and other materials specifically for the page 163. Buyer's agent. Professional organizations offer assistance, certification, training, and networking opportunities. A buyer-agency relationship is established in the same way as any other agency relationship, by contract or agreement. The buyer's agent may receive a flat fee or a share of the commission or both, depending on the terms of the agency agreement. Property management. An owner may employ a broker to market, lease, maintain, or manage the owner's property. Such an arrangement is known as property management. The broker is made the agent of the property owner through a property management agreement. As in any other agency relationship, the broker has a fiduciary or statutory responsibility to the client-owner. Sometimes an owner may employ a broker for the sole purpose of marketing the property to prospective tenants. In this case, the broker's responsibility is limited to finding suitable tenants for the owner's property. Some states recognize a special real estate license for those who exclusively handle property rentals. A broker can also represent the tenant of either residential or commercial property. A knowledgeable real estate broker is an important resource for a transferred employee needing suitable housing, as well as for the owner of a business seeking to find a larger or smaller property to expand to an additional location. Dual agency. In dual agency, the agent represents two principals in the same transaction. Dual agency requires equal loyalty to two different principals at the same time. A high burden that means neither principal has the full, undivided loyalty of the agent. Dual agency arises, for example, when a real estate broker is the agent of both the seller and the buyer. The broker sales associates as agents of the broker also have fiduciary or statutory responsibilities to the same principals. The challenge is to fulfill these fiduciary obligations to one principal without compromising the interests of the other, while practical methods of ensuring fairness and equal representation may exist. It should be noted that a dual agent can never fully represent either's party's interests. Because the duty of undivided loyalty cannot be shown to both principals at the same time. Similarly, it is impossible to maintain both confidentiality and full disclosure to parties whose interests are in opposition. See Figure 10, period 3. Figure 10, period 3, dual agency. It shows the agent on top and two straight arrows, solid ones, to the buyer and seller. Because of the risks inherent in dual agency, ranging from conflicts of interest to outright abuse of trust, the practice is illegal in some states. In those states where dual agency is permitted, all parties must consent to the arrangement, usually and always preferably in writing.